Hello, my name is Perera and I'm the Director of the Legal Department at UHY Fay Co. And today I would like to give you some hints of the key essential legal issues that should be taken into account by any seller that may be considering the possibility of selling his company. So first thing it should be borne in mind is that even though a seller might not be considering the possibility of selling his company in the short term, it's still worth it to start working on it and planning the whole procedure properly to be ready when the time comes. Most of the small to medium-sized companies are not really the target of interest of many purchasers. There might be one or two purchasers interested in your company. So it is very important that when the time comes and an interesting opportunity arises, you don't miss it, and to that end, you should be ready in advance. So if we think about the main steps and topics that should be assessed in order to plan this transaction process properly, all these may be summarized by responding to very basic questions that any seller should ask him or herself. We find out that in many occasions, family companies or sole shareholder companies have in their own balance sheet assets that are not really linked to the business activity that the seller would like to sell. Or maybe there are different lines of businesses together and it doesn't make sense that one of them is included in the scope of the transaction. So first thing that needs to be done is to assess what assets and what liabilities and what lines of business make sense to be transferred. If there are any personal assets, we should tidy up our company, and we may need to undertake restructuring of the group. So this would be like a preliminary stage of the procedure, which takes time. And it is necessary to plan it in advance because when the purchaser that's really interested in our company arises, we should have completed this stage first. So most of the times we may need to carry out a share exchange or a spin-off, or maybe a share capital increase by contribution in kind, but there may be many other actions that need to be undertaken depending on the case that we are facing. Depending on how we respond to this question, we may need to approach to a different profile of purchaser, and this kind of purchaser will very much have an impact on the specific measures and planning that we need to undertake. For instance, if you are dealing with a potential investor that's willing to acquire a controlling stake, he or she will very much require that the due diligence is carried out in a very deep detail. Whereas if you are dealing with someone who's interested in acquiring just a minority stake, he or she would be more concerned about knowing the detail on how the company is going to be managed when they join your project. If you stop and make this assessment, and to this end you should use two most important tools, you will be in a much better position to negotiate your deal. So these important tools that any seller should rely on would be a valuation of your company performed by an expert, because this valuation will enable you to be aware of what's the real value that your company has in the market. And this will depend on what a third party is willing to pay for it. It doesn't matter what you want to get for it, but what someone objective can, based on facts, argue that the company is worth. And the second tool that you should rely on would be a vendor's due diligence, which is something that a purchaser would normally do, but it's very important that the vendor also does, because it helps you to assess where you really stand and if there are things that could be done in a better way, it will help you to mitigate risks and increase the value of the company. Because sometimes it doesn't depend purely on us, and we need to seek the approval of back entities, or we need to seek the approval of very important clients with whom we've signed contracts with change of control provisions, or maybe we are the title holders of very important licenses that are like the core of our business. So if we're going to change who's the controlling of those licenses, we need to ask to the authorities or administrative bodies to approve the transaction. So it is important to be aware of all these requirements that are beyond our control, because if we find ourselves in a situation where we need these approvals when the deal is almost there, this could become a deal breaker if the seller wasn't aware of that and the purchaser is not willing to wait. For this reason, you should rely on your advisors to let you know where you stand in advance. Because sometimes, even when you are dealing with a purchaser that would like to acquire like the whole stake in the company, they still want you to continue to be involved, to help you with the management for an interim period until they get to know the business in detail. And sometimes this may be very useful for the seller to be offered a higher price for the transaction. Whenever the seller continues to be involved in the management, it's easier to get a higher variable tranche that it's usually linked to the performance of the company. So if this were the case, you really need to pay attention to what legal and contractual measures you need to undertake to protect your earn-out or your variable, to make sure that all these expectations on the value are completed.